Y- y- Your Honor, that was one of the things that the council wanted to present, that this very impugned legislation lacks any forms of checks and balances that would ensure that the central government can A, neither misuse this information, B, not get this information in any manner that is not prescribed by law. And therefore, Your Honors, since there are no checks and balances in order to ensure these two things, there is a very...
Council, that's a ground to strike down every single law in this country. We will not be left with any laws. Every law can be misused if somebody puts their mind to it. That is not a constitutional argument that you're making here. That is just a general argument here. Please tell us what is problematic about this particular scheme. Absolutely. You started off with Article 1415, now you're generally gone to misuse, bad things will happen, bad people are there. That's all just basic street debate. That's not a constitutional argument. Please tell us what is constitutionally impermissible about 7 clause 4 of the scheme.
Absolutely. Your Lordship, what is constitutionally impermissible in the given case is the information imbalance that this scheme is creating. The information imbalance is in such a fashion that on one hand, there is information with respect to political parties' donations, Your Honors. This information, on one hand, is not at all available to the masses, which in turn is a gross violation of Article 19(1)(a) that the Council will later deliberate upon.
Council, census data is also available with the government. You want us to strike down the Census Act?
Pardon, Your Lordship, you were not...
Census data is also available with the government, not with the masses. You want us to strike down the Census Act?
Absolutely not. Your Honor, there is a...
So how can there be one standard for that and one standard for this?
The problem, may I say, the problem is equating central government, you're equating the central government with the political party. The moment you divide both of them...
Your Lordship, pardon, but there is no audible clarity.
Yeah, the moment what's happening in your case is you're equating central government with a political party. You can't mix both of them. When a party in the central government is different, you cannot say that they're going to misuse in a general front unless a specific instance is placed before the court.
Absolutely.
I think just to add to that, I think the question you have to address is that when you say information asymmetry, who is the information asymmetry between? Absolutely. And why is that asymmetry a constitutional issue? Absolutely. In this case? So if you could perhaps convince us on that, then that would be a good thing.
Absolutely. Your Honor, I shall answer this question in a twofold manner. First of all, who is the imbalance between? Your Honor, the imbalance is between the state and the people herein, and as Your Honor has rightly pointed out, that it is not always necessary that all data needs to be available with the masses. However, what the Council is trying to present before this Honorable Court is that this information regarding donations being made to political parties should be informed to the voters in order to facilitate their right to informed vote, Your Honors. Your Honor's right to informed vote has been held to be a part and parcel of Article 19(1)(a), which is a constitutional mandate and a constitutional guarantee, Your Honors. Your Honors, furthermore, in the given case, it is, as it was observed by the United States Apex Court, and that lays down the rationale as to why this information needs to be available to the masses, is that for them to ascertain three things. A, true inclinations of the political parties. B, any lobbying or quid pro quo relations the political party may have with their donors. And C, the true agendas that the political party may legislate upon, depending upon their quid pro quo relations, Your Honors. Therefore, it is contended that this information regarding political donations must be made available to the masses, Your Lordship, and that was the exact scheme that the law used to follow earlier. Section 20.
Counsel, you don't have to answer this right now, but at some point answer this. Now, they will come and say that you have to have privacy to prevent reprisals from the government, you know, if people they don't like are voting, donating to other parties. Yeah. And so if we are faced with two conflicting rights, the rights of the voter to know and the rights of the citizen to be able to support political parties anonymously without fear of reprisals, what legal standard should be used to balance those rights?
Absolutely.
So at some point when you're making this argument, just address that.
Absolutely, Your Lordship, I shall address this. Your Lordship, as the Council was iterating, that this information becomes very relevant for a voter to ascertain whether he or she is going to vote for the political party, and will that political party make the promises that it makes prima facie. And if this information is not made available, Your Lordship, the very essence of free and fair elections, free in the sense, would be violated because there would be no free-flowing information available. How would fairness be violated, Your Honors, in the given cases? That since people are not being able to make an informed decision about the government that they are finally electing, that is very unfair on the part to have limited information regarding the people who are ultimately going to govern them.
Coun-
So you're saying by voting, you're actually electing the government straight away. You're not voting for candidates. You're voting for government.
Absolutely not, Your Ladyship. What,
And you're establishing that my vote is actually going to result in a particular government. Like, does the voter have that much of control over the entire process?
Your Honor, what has been observed in the case of Kyoto Holon was that it is deemed by the court that a voter elects a political party and not a candidate. The rationale behind holding the same was, Your Honor, there was a slip of tongue and I seek apology for that. However, what the council is trying to establish is that even though it was held that the right to informed vote only exists against a candidate, as it was the law established under PUCL versus
Council,
India.
if we grant your relief and strike down the entire scheme of electoral bonds, what is the regime that will apply for fundraising?
Your Lordship, there already are multiple forms of other political donation.
What is the legal regime? If we strike down the scheme, what will be the legal regime for raising funds? And does that provision mandate that every person who gives a single rupee to the political party should disclose their identity?
No, Your Lordship.
Then
Your Lordship, how?
all you're asking us to do is to strike down to replace one unconstitutional law with another unconstitutional law?
Absolutely not. Your Lordship, what is happening in the given case is that the quantum of donations that can be made in the form of electoral bonds can go to any amount, and that any amount will not be available to the masses.
Counsel, is there solid data on this? Please, we don't want arguments in the air about quantum.
Well,
Do
pardon
you
me,
have
Lordship.
solid data about how much money has gone to various parties?
Your Lordship, the council is not going on the objective data about the money that the political parties
And
have.
how can you potentially say maybe tomorrow, who knows what will happen? We don't decide cases on that basis. We either need a good principled argument or show us through data on the facts that this is what has actually happened.
Your Lordships, for the sake of that argument, the council would like to draw attention of this honorable court to paragraph number 7, if your Lordships may have it, of the Moot proposition. Your Lordship, 60% of the total contribution that were made to the incumbent government in their political was that 60% of the total contribution that the incumbent government was in the form of electoral bond. Your Lordship, now this is a large sum. Even if for an instance we assume.
You have data on how much money was received by the previous governments when the electoral bond was not. Because that becomes a comparator. If you need a comparator to say this is excessive or not, there is a comparator.
Your Honor, where
And
the
just to add to that, there's a well-known feature of incumbent bias because
Right.
incumbent, the parties or incumbent tend to get more donations because, patronage and so on. So I guess you need to show us why is this disproportion so great that it raises a constitutional concern.
Your Lordship, the concern is not with respect to the quantum of donation. The concern herein is with respect to the availability of information, and the council shall elaborate that there exist multiple forms in which a political party can be donated. One being cash, other being checks, demand drafts, net banking, and now a new creation.
You have data on what was the contribution before the scheme was in place?
Your Honor, there is no available data on regards to the same, and therefore the council is not going on the quantum of the data. The council is
Even if not quantum, availability of data. What is the data available under the present scheme?
uh,
Because you have made all the news. What is the data with reference to when the scheme was not in place? Did you have the data at all or you didn't have the data?
Your Honor, Your Honor, the time is up. The council seeks permission to extend the time by 5 minutes, if Your Honors may allow. 5 minutes extension? Much obliged. Your Honor, the facts remain silent on what was the quantum of donations before the scheme was introduced. And Your Honor, that what is being contended herein is that the earlier that the scheme existed was that every political donation in excess of 20,000 rupees was reported to the Election Commission by virtue of application section 29C of the RPA. However, now the same provision of 29C has been amended, and a proviso has been added to it, which excludes only donations made in the form of electoral bonds, even if they are above the bar of 20,000 rupees, not to be reported to the Election Commission. So in order to draw an illustration, even if today 50,000 rupees are being donated through check, that will be reported to the masses by means of the application of section 29C. However, if the same 50,000 is donated in the form of electoral bonds, this will not be repealed. Your Honour, what this is doing is this provision itself is creating a way for ascertaining anonymity to the lobbying that can exist. And Your Lordship, this how this would happen is, ultimately there are only two people who are getting to know that who is the donor and who is the donee. In this given case, Your Honours, the political party who is getting the donations is ultimately getting to know who the donor is, because these bonds have to be submitted to the political parties and then encashed by the political parties. Therefore, Your Lordship, the only two people in the given case who get to know about these contributions are the donor and the donee, and not the rest of the voters. Your Lordship, this is the information balance that the council was trying to establish. Your Lordship, this violates the very facet of the right to informed vote, which in turn violates the very concept of free and fair elections, as the council has already iterated. If Your Lordships have no further questions with respect to this part, Your Lordship, I'm so sorry, there was one question with respect to the balance that needs to be.
Given the time you have, just flag it in 20 seconds and then quickly move to your second issue.
Certainly. Your Lordship, it needs to be noted that there could have been multiple other ways, multiple other least restrictive measure in which the anonymity of the donor could have been protected, or even if the anonymity can't be protected, then it could have been ensured that this information is not A, misused, or B, even if it is misused, there are penal provisions for it, and C, it cannot be unlawfully obtained. These three things, if had been ensured, then even if privacy would not have been offered, that would not have been a grave concern, Your Honours. May the council proceed? Much obliged. Your Honours, moving on to the second issue at hand, which calls into question the constitutional amendment that puts a freeze on delimitation. Your Lordship, Your Honours, the scheme of delimitation under Article 327, 81 Clause 2 and 170 Clause 2 was that the territorial constituencies have to be arranged in a fashion that the representation of people, that the proportion of people in each constituency is as far as practicable equal. So ultimately the delimitation laws were trying to achieve equality in terms of representation and were ascertaining on the threshold of practicability the value of one person, one vote, one value. Your Lordship, however, the last time the constituencies were equally delimited was way back in 1971. 5 decades have passed. 53 years to be precise have hence. Your Lordship, Your Honours, the population in the constituencies has either increased or decreased disproportionately. We have no record to say that.
Council 329A.
Yes, Your Honours.
Article 329.
320.
Clause A. The validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies made or purporting to be made under Article 327 or 328 shall not be called in question in any court.
Absolutely.
How are you in hearing this case?
Absolutely. Your Lordship, the bar only up. Your Lordship.
Yeah, also, I haven't seen a response in your memorial to this point. So I'm just wondering, is it there or
There is a response, Your Lordship. The response being very simple, that the bar of Article 329 would only apply in cases when there are laws made under Article 327 and 328 as the Constitution itself reads. However, what is being called into question here is not the process or laws of delimitation, but the very freeze on the delimitation that has been put, and that too not under Article 327 or 328, but under Article 368 by means of a Constitutional Amendment Act. And therefore, this bar of Article 329 does not apply.
Are you saying that the entire delimitation exercise, every single thing since 1971 should be set aside?
Absolutely not, Your Lordship.
Every election since that amendment should be set aside for that reason.
Absolutely, Your Lordship, that would not be a practical scenario to hold in. However, what errors have happened earlier, they can be corrected now, and delimitation can be conducted now in order.
Time is up. So time is up.
Is there?
You can move on to the next.
Your Lordship, could I seek an extension of 2 minutes?
No, I think we've
I think
already-
you're done.
No problem, Your Lordship. The council seeks permission to invite the co-counsel to the stand. Much obliged.
Am I sufficiently audible? The council recognizes the gracious presence of your ladyship. However, for the convenience of proceeding, if your ladyship allow me to address the bench collectively as your lordship or as your honor, according to the convenience, the council would be grateful for that.
We've already been over this, and you don't have to repeat.
Actually, yeah, ladyship has opposed that I can't address the bench as your lordship. Ma'am, may I?
Your Honor.
Your Honor, the Council will be dealing with two chief issues at hand. Firstly, whether Section 8B of Representation of People Act is liable to be struck down on being unconstitutional, and secondly, whether Section 62 Clause 5 of Representation of People Act is liable to be struck down on unconstitutional. Firstly, moving on to the first issue at hand, Your Lordship, there's Section 8B of Representation of People Act, which provides for the bar on right to contest election for the individual merely on the basis of framing charge is unconstitutional. In order to establish that, the Council will be making three chief submissions. Firstly, it is violative of Article 21. Secondly, it is violative of Article 14. And lastly, it is violative of Article 19. Your Honor, before proceeding to my submission, I seek your permission to pass some documents pertaining to same, if you may kindly allow. May I? Much obliged. If I may have your attention, Your Honors. Your Honors, may I proceed? Much obliged. Your Honors, coming to the first submission that it is violative of Article 21. Article 21 provides for right to life, and under that article, Your Honors, the aspect of presumption of innocence has been implicitly recognized by this very honorable court.
Sorry, Counsel, just 1 second before you go on that argument. I can understand an Article 14 argument here that the distinction is irrational.
Indeed.
When you're arguing Article 21, what aspect of 21 are you pegging the case on? Is there a right to contest that you're saying is fundamental, or is there something else? What is the Article 21 violation that triggers your next level of argument, which is, presumption of innocence and so on?
Your Honor, the aspect of firstly the presumption of innocence has been violated, which has been recognized as a right under Article 21 in the case of Sahara. You may kindly refer to footnote number.
No, but nobody is jailing anyone without proof of guilt. This is not a question of presumption of innocence in the criminal law sense. Are you saying that Article 21 carries with it a right under any circumstances that no law that is made, whether it's a civil law, an election law, can ever depart from that presumption, independent of establishing any other right that's being violated by that law?
Not your.
Is there a presumption of guilt as much as prescription of conditions? There's a distinction between the two, right?
Indeed, your Ladyship. First, answering to the question what my Lordship has asked, Your Lordship, what we are contending is that if even you want to restrict the right, it should be restricted in the accordance with procedure established by law. And the right that we are contending here is right to contest election, firstly, and the right to reputation, which is also a part and parcel of Article
Okay,
21.
so your base threshold right is the right to contest election, not the right to presumption of innocence, right?
Your Lordship, we are dealing with both the right at parity.
No, okay. I'm trying to understand what your argument is resting on. One, you can say that there is a freestanding right under Article 21 to the presumption of innocence that applies across the board, so no law can ever depart from that, whatever else it says. Or you're saying that there is a right to contest elections, and that this law impermissibly violates that right by establishing a condition that effectively departs from the presumption of innocence. So which is the argument? And when you do so, also please answer the question about the distinction between conditions and restrictions.
Your Honor, I would like to draw your attention to the documents which I have passed. We are contending here on the aspect of cause and effect relationship. The impugned provision section which is in challenge is section 8B. Your Lordship, the aspect of cause is framing of charges, and that framing of charges is leading to the effect which is the disqualification of individual from contesting election, which is called into question here in Your Lordship. Further, Your Honors, the that in the course of trial, there are two effects from the same cause. As I have highlighted in the illustration, you may see, honors, that the commencement of trial is one effect, and simultaneously the disqualification of the individual from contesting election against whom charges have been framed. Now, Your Honor, on the one hand, the impugned provision is treating the individual as a innocent. However, on the other hand, there exists a presumption of guilt. So, Your Honor, the aspect is same because it is assuming from the, it is coming out from the same cause. However, it is treating two different effects at the same time, which is contradictory in itself, and therefore it is violative of Article 21, Your Honors. If Your Honors have no preliminary inquiries on this argument.
Counsel, government servants can be dismissed from service if they spend 24 hours in jail, even without having been convicted. That is perfectly valid under law. So where is the contradiction? They may be eventually acquitted. They can still be dismissed from service on the same facts. And I can't even mention the number of judgments which have said that there is nothing contradictory about one proceeding finding you guilty, or putting guilty in quotes, because one is guilty in a civil proceeding, the other is guilty in a criminal proceeding. One is guilty in a civil proceeding, one is guilty in a criminal proceeding. Where is the contradiction? These are two very different kinds of proceedings. For the purposes of election, we are saying that if it is serious enough, you won't be allowed to stand as a candidate for the election. Where is the contradiction?
Your Honor,
Presumption of guilt. There is no presumption of guilt.
Your Honor, on that aspect, firstly, the class of individuals that have been called into question by Your Honor's question is that the government individuals are different from the government servant are different from the
Counsel,
individual.
Article 21 doesn't say that.
Exactly, which is why people contesting elections and others are different. Same intelligible differential.
So in that aspect, Your Honor, the aspect that we are trying to contend here is the aspect of presumption of guilt, as you asked. Your Honor, the presumption of guilt exists because of the framing of charges itself, we are disqualifying the individual. So framing of charges per se does not mean that such individual
Counsel,
is
what are the
culpable.
other criteria for disqualification of an individual from standing for elections? Is this the only criteria?
According to the impugned provision, it
Representation of the People's Act.
Your Honor, under Section 8 Clause 3, the conviction is the criteria.
Then,
Your Honor, that's the whole point in
what are the other grounds for which you may be barred from standing for elections? Look at the Representation of People's Act.
if such individual is involved in any if such individual who is contesting election has found guilty of or violating the public order and all that allied things.
So there are a bunch of criteria which
Indeed.
can disqualify you,
Indeed.
right? This is just one more criteria.
Your Honor, but the problem with this criteria, it is trying to equate the already existing provision, which is Section 8 Clause 3 of Representation of People Act, with the...
Where is the equality? There, conviction for an offence punishable with at least 2 years. Here, framing of charges for an offence at least 5 years. There's a clear difference. It's not like as if the same offence which can get you disqualified on conviction, just when charges are framed, will also get you disqualified. There are clear differences between the two. So where is the equating?
Your Honor, in order to answer that question, I would like to draw your attention to the very fact that here two classes of individuals are involved. Firstly, the accused, and
Please
secondly,
clarify to us, counsel. Are you dealing with Article 21 or Article 14? When my learned brother asked a question on Article 21, you suddenly go to two classes of individual. Now when I'm asking you on Article 21, again you decided two classes of individual. Please clarify what is the fundamental objection constitutionally you have. I don't care about what you may feel about it personally or in any other aspect. What is the principled constitutional objection you have to this clause?
Your Honor, firstly, under Article 21, we are contending on the presumption of innocence. Under Article 14, we are basically, I will be submitting in my further submission that is not adhering with reasonable classification. And in totality, we are telling to or contending this honorable before this honorable court that rights are restricted in unreasonable manner.
Where does the question of reasonableness come here?
Under Article 14, Your Honor.
Okay, just go into Article 14 argument.
Your Honor, under Article 14, it needs to be noted that test of reasonable classification should need to be adhered in. However, in the instant provision, that's not the case because it is classifying individual in two classes of people. Firstly, Your Lordship, the accused is one class of people and convicted is another class of people. What has been provided in the impugned provision, if a charge has been framed against any individual, such individual gets disqualified from contesting election. Your Lordship, I would like to draw the attention to an...
Counsel, could you just slow down a little bit, please? Just slow down a little bit. Thank you.
Apologies. Your Lordship, if I would like to draw your attention to the analogy herein, that accused is a class of people against whom charges have been just framed. However, the convicts...
No. Accused is not just people against whom charges have been framed. You are factually wrong there. Accused includes much more than that.
In that aspect, I would like to correct myself, Your Honor, that it is one of the aspects in which that accused is a individual against whom charges framed. However, convict is the individual against whom charges has already been proved. What impugned provision is trying to do, it is equating the accused with that of convicted person, because it is trying to disqualify the individual on the very basis of framing of charge. Thus, it is presuming the guilt of individual then and there. That's why it is violative.
Counsel, sorry, what are the two groups who are being, what are the two classes here in your view?
According to the impugned provision, two groups is against the individuals whom charges have been framed is first, and against the individuals whom charges are not been framed.
Okay, and so you're saying that the individuals against whom the charges are not being framed are being treated better by being allowed to contest as opposed to those against whom charges have been framed. Is that what you're saying?
No, Your Lordship, in that aspect, what I am trying to contend that the classification that has been provided pertaining to the charges of against charges have been framed. They are trying to again equate the same thing with Section 8(3) of the Representation of People Act, which is already in place.
No, that my brother has already put to you, that's already a distinction over there. So it's conviction for a somewhat less serious offense and charges which are at a more preliminary stage of the criminal process for a more serious offense. So I'm still trying to understand, when you're saying Article 14, which are the two classes who are being treated differently in a manner that violates I'm assuming the twin test is what you're going on, that violates the twin test.
Your Honor, in that aspect, the charges framed is a one class of individual and the charges proven is another class of individual therein. However, the impugned provisions first limb, which is charges framed against individual, is treating both of them at parity. So the first limb itself is provides a discriminatory aspect therein. That's what counsel is trying to establish in the instant case.
So you're saying that ideally it should only be conviction. The disqualification should kick in only on conviction, and if you're treating people who have not been convicted as unfavorably as those who have been convicted, then that for you is where the violation lies. Is that the argument?
Indeed, Your Lordship, because already we have Section 8 Clause 3 in place, which already convicts the individual. And if the counsel is unable to understand the basic aspect of...
For a moment, forget 8 Clause 3.
Indeed.
Just focus on your Article 14 argument, right?
Yeah, Your Lordship, yeah, the council has contending on the aspect that you have just rightly mentioned, that we are trying to establish that on the merely basis of framing of charges, that framing of charges is per se treating the individuals differently. So that's why it is violative of Article 14. If Your Lordship have no further preliminary inquiries, the council seeks permission to proceed with another limb of this submission. Much obliged. Your Lordship, I would like to draw your attention that Article 19 Clause 1, Subclause A is also violated by the impugned provision, because right to contest election is a form of expression under Eurasian democracy. Article 19 provides for the freedom of speech and expression, Your Lordship. Further, I would like to draw your attention to the footnote number 215 of the memorial submission. In the case of Bimal Gurung, the Apex Court has observed that, I will read it for you, political demonstration which violates law and order are not protected under Article 19, Clause 1, Subclause A, as it has been struck down by Article 19, Clause 2, as a reasonable restriction. However, your lordship, interpreting it in the harmonious, however, your lordship, interpreting it in the other way, the political demonstration that does not violate law and order are protected under Article 19, Clause 1, Subclause A, not struck by Article 19, Clause 2. Your lordship, political demonstration depicts the idea of expression, and expression has been explicitly protected under Article 19. Thus, your lordship, right to contest election is also protected under Article 19. Even if government wants to restrict the right to contest election under Article 19, it should be doing in accordance with the reasonable restrictions as provided under Article 19, Clause 2. In that aspect, the 19 Clause 2 nowhere mentions that the political expression should be curtailed. So in that aspect, your lordship, again the reasonable restriction cannot be called into question for the impugned provision. Thus, in the view of same, your honors, it is humbly submitted that the impugned provision is violative of the Article 21, 14 and 19.
Just one question, why doesn't the decency and morality prong of 19.2 apply here? Because the idea being that election process requires a certain kind of moral purity, and if you have reached the stage of framing of charges for serious offences, then you fail that moral threshold that society needs to have clean elections. So why isn't it hit by that subclause of 19.2?
Your Honor, on that aspect, it needs to be noted that constitutional morality shall called into be question and not a public morality per se. So that's why it is not in the ambit of Article 19 Clause 2.
Why isn't a clean election part of constitutional morality, whatever that term might mean? Why can't that be part of constitutional morality?
Your lordship, it needs to be noted that on that aspect, balance of convenience needs to be have been seen by this court, and doctrine of purity of election, as your lordship have highlighted right now, is per se providing that free and fair election should be held. However, what the impugned provision is doing, it is per se barring the right to contest election of that individual. In that aspect, how we can assume a free and fair election, because it is not providing the right to participate in an election.
You're on Article 19 right now. Right, so could you just stick to that when you're responding? 19.2, my only question to you is that why isn't the decency and morality prong applicable to this case? You may say that it's still an unreasonable restriction, but how can you say that 19.2 isn't attracted at all in the first place? This is my only question to you.
Your lordship, it is at the end of the day, it is the interpretation of the judiciary. However, from the side of petitioner, the council submits that Article 19 Clause 2 is not attracted because firstly, there is no explicit mention of the political expression, and secondly, under the aspect of morality, if we want to interpret it, it should be constitutional morality. Under constitutional morality, the doctrine of free and fair election will come into call, and when it will come into call, in that aspect, if you are restraining someone from contesting election itself, then it is not providing for free and fair election.
Counsel, if there is somebody who has 30 murder cases, charges have been framed in 15 of them, is standing trial, who do you think will stand in election against this person?
Your lordship, in that aspect, the council would like to submit that.
I mean, if you put yourself against as a competing candidate, if you know your opponent has 20 cases, charges have been framed, would you want to risk your neck to stand in elections?
According on the hypothetical situation answering.
It's a very real situation. I can list out the names, but I might be causing defamation, but I can list out all the names also. Can it be free and fair elections when one person is walking around free, no consequences for having this many cases against them? Do you think anybody will even dare stand?
Your Honor,
And tomorrow, if this person gets elected and becomes Home Minister, do you think democracy stands any chance?
Your Honor, firstly, to answer your query pertaining to that, the basic principle that we follow in the Eurasian democracy is innocent until proven guilty, and the charges have been just
Counsel,
framed against.
at some point you'll have to balance.
Indeed.
Either we say innocent and proven guilty, or we have free and fair elections. You tell us which is more important for you. We'll say that. We'll say it's not important to have free and fair elections, innocent till proven guilty. If tomorrow the Home Minister has 40 cases against him and he decides to get all those 40 cases thrown out of court, too bad, we had free and fair elections. Is that acceptable? Is that an acceptable outcome to you?
Your Lordship, in that aspect, as you have rightly pointed out.
Is it an acceptable outcome to you?
No.
You're a citizen of this country.
No.
You live here.
No,
So
no,
we're
Your
protecting your rights only.
Your Lordship, but that is not every time the case. However, the impugned provision is providing for a blanket ban per se. So that's why that argument has been put forth by the
How would you like us to, sorry,
Yes,
go ahead.
go ahead.
Should we rephrase it? Should we read it down, modify it? Are there any proposals you have? If you're saying that not every case will be like this, are there any alternatives you have that we can do that doesn't involve striking it down, but maybe reading it down, modifying it, something of that kind?
Your Lordship, as the question has been raised by you, if government really wanted to adhere with the recommendation of 244th Law Commission report on which this impugned provision has been framed, on that aspect, there should be a distinction of offences that has been covered. The government has used the term all criminal in all criminal cases. However, Your Lordship, it might provide for a distinction firstly. Secondly, adequate safeguards can be provided in order to prevent the misuse of provision. And lastly, Your Lordship, further while distinguishing the distinction, cognizable, non-cognizable offence can also be reiterated therein. The Council seeks permission to proceed with the other issue at hand if Your Lordship have no further queries. May I? Much obliged. Your Lordship, the other issue at hand is whether Section 62 Clause 5 of Representation of People Act, which bar all the prisoners who are lodged inside prison to vote in an election. The Council will be dealing the issue in 3 chief submission. Firstly, Article 14 is again getting. Your Lordship, the Council humbly request for the extension of 5 minutes, if you may please permit. Much obliged. The Council will be dealing with the instant submission that firstly it is violative of Article 14, secondly it is violative of Article 19, and lastly it is violative of Article 21. Your Lordship, the bar on all persons who are confined in prison to vote in an election is unreasonable by instant provision, because Your Lordship, the classification which instant provision is providing between 2 classes of individual. Firstly, the individuals who are lodged inside prison and the individual who are outside prison. However, it is a stark reality that if an individual who is an under trial, if that individual gets a bail, he will go outside the prison. Then such individual falls under the ambit of second class and he is entitled to vote. Then and there the whole object of the impugned provision gets defeated, which is the decriminalization of politics in Eurasia. In the said aspect, Your Lordship, it is not adhering with the principle of reasonable classification. Firstly, because there exists not any intelligible differentia, and secondly, there is no rational nexus with the objective for which it was enacted. If Your Lordship have no preliminary inquiries on this submission, may I proceed? Much obliged.
I'm just curious about one thing. In your previous argument, you went quite strongly on the right to contest, as an important right. You began with that Article 21. Here you're going straight to 14. Don't you have a problem with the fact that the right to vote as a right has been taken away before you even get to like 14? Isn't that something that you think is important, or is that something you're not pressing?
Your Honor, I would like to highlight the aspect that adequate principles while determining both the issues should be treated differently, because both the rights are different firstly, and secondly, Your Honor, on that aspect, the aspect of personal liberty calls into question in both the things in different facts. So the distinguishing of facts has been called by the Council for the different submission, which appears to be contradictory but not in actually they are contradictory.
I'm not saying it's contradictory. I'm saying it just seems that you've somehow given more stress to the right to contest, which is arguably a weaker right, and less stress to the right to vote, which is, I think, it seemed to me a stronger case that you have. But of course, it's your argument, so please go on.
Much obliged, Your Lordship. Your Lordship, moving on to another limb of this submission, that impugned provision is also manifestly arbitrary in its nature, because it is based on the irrational and capricious concept of civil death that was followed in earlier times. However, we are living in 2024 now, and thus the very basic aspect on which the impugned provision has been enacted is not the reasonable one. Further, adequate principles has not been followed while enacting the impugned provision, because it is again providing an unreasonable classification on both the things. Because if any individual who might be convicted, and if such individual gets out on parole, then such individual is entitled to cast a vote, and the objective of impugned provision is to restrict the right to vote of all the individuals who are restricted inside prisoners. Thus, it is violative of Article 14 in totality. Now the Council would like to move with the another limb of this submission, that it is violative of Article 19. Your Lordship, the freedom of speech and expression is part and parcel of Part 3 of the Constitution. Further, in the case of ADR versus Union of India, Your Lordship may kindly refer to footnote number 262 of the memorial submission on page number 28, in that aspect it has been held that the right to vote is a part of expression, and it is a formal expression in order to recognize the will of people to whom they want to elect. So in that aspect, Your Lordship, it is violative of Article 19. Further, the same thing has been again reiterated in the case of PUCL versus Union of India. Your Lordship may kindly refer to footnote number 260 on page 28 itself. Your Lordship, further, if even government wants to restrict the right to vote on being account that it's not explicitly a fundamental right, however, impliedly it is a part of fundamental right and part 3 of the Constitution, that right should be restricted in a reasonable, that right should be restricted with a reasonable aspects. However, that is not.
Please tell us how you are arguing against Javed as well as Rajbala, because you haven't mentioned those in your.
Sorry, Your Lordship.
Those are two cases which have imposed restrictions on the right to vote as well. The Rajbala decision as well as the Javed decision have imposed restrictions on the right to vote. So what do you want us to say about those decisions? Aren't those binding on us?
Your Lordship, first of Rajbala, if I heard right, Rajbala was state of Haryana. Your Ladyship, in that aspect, it needs to be noted that decision has been greatly criticized by the academician.
Criticized, but it's a binding ruling.
Indeed,
You
indeed,
haven't mentioned it.
indeed, indeed, indeed. Your Ladyship, in that aspect, for this is a constitutional bench. Your Ladyship, the council seeks extension.
You have to explicitly ask us to overrule that, isn't it?
Indeed.
You haven't done that.
Your Ladyship, I will be coming to that point in my oral submissions. So in that aspect, further, it was not a constitutional bench judgment. However, the present bench is a constitutional.
Grounds do you want us to overrule it?
The Rajbala decision. Your Lordship, firstly, that decision was dealing with the Panchayati Raj enactment and the impugned provision in cause is representation of people.
Principle the same. Principle of whether there can be any restrictions on the right to vote.
Indeed, Your Lordship, but the veracity of that vote differs from that case to in the instant case. Because, Your Lordship, in that case, the question that was called before this Honorable Court is pertaining to ascertaining the qualification which has been laid down pertaining to education of the contestant who want to contest election.
It's a far more egregious violation of the right to vote. When the state itself has not guaranteed the right to education to everyone, how can it disqualify people on the ground of education?
Your Lordship, because in that particular case, the facts were related to the Haryana and Haryana specifically, and in the Haryana, Your Ladyship, the literacy rate is not that high, and that was the statutory enactment per se for the state itself. That's why I request this Honorable Court to overrule that judgment.
On what ground? You're not giving us the ground.
Your Ladyship, the ground for overruling that judgment is that the basic rationale that has been provided by the court for per se citing the decision is that educational qualification cannot be a per se criteria.
The classification test and held it to be perfectly reasonable. So on what ground do you want us to overrule?
Your Lordship, the very basic element, like in the impugned provision, it is the prisoners who are lodged inside prison. At that aspect, it was education, and the education cannot be per se a determinative factor pertaining to the contesting the election, because it is not necessary that an individual who is, it is accept.
Not giving us grounds.
Your Ladyship, I would like to seek an extension. I would request for 2 minutes. Much obliged. Your Ladyship,
We say no.
may I proceed to prayer, if you may kindly permit?
Prayers on record, so it's fine. Yeah.
Much obliged. It was indeed a pleasing, it was indeed a pleasure before contending you.
Just a second, just want to sort of.
Before I start, am I audible?
Are there pages missing in your brief? Mine's going from 14 to 19. Yeah, this the brief. This one. Is it also? 14 to 19. It's going straight to 19 from 14. Yeah. Yeah. We have pages missing in all our briefs. Yeah. Yeah. Sorry, there's some pages missing in the memorials that have been given, so we'll just get the conclusions.
Honorable bench, if may we address that issue?
You've gotten the wrong.
Anytime you want.
With respect to that, we'd like to submit that it was a typing and syntax error. We informed the organizing committee. They said they'll take note of it.
No, it's just that we have some pages missing. All our briefs have around 4 pages missing, so we're just hoping they'll get the updated ones soon.
It must be from their side. We have all the pages in our memory that we submitted. Yes, this is so the cover page was a syntax and typing error, which we informed the organizing committee. This is 14R, not 14P. But for the missing pages, we provided all the pages in the memorial. We have the e-copy of that as well, and the physical copy as well.
Yeah, no, I think there's been some mistakes, so we have been all given incomplete briefs. So
Okay. Do you want to wait for copies or shall we just? We'll just.
Council solicits permission to begin. Much obliged. If it may please the court, the council solicits permission to collectively refer to the bench as your ladyships and individually as your lordship and your ladyship. Much obliged, your ladyships. Your ladyships, we stand before you representing the state, that is the respondent in the 4 petitions filed against the state, and the current council shall be dealing with issue 1 and 2 of the proposition, and will be taking 20 minutes of this honorable court, followed by my co-counsel, who shall be dealing with issue 3 and 4, also taking 20 minutes, humbly reserving 5 minutes for Sarah Bartels. Your ladyships, the first issue that we shall be dealing is with respect to introduction of electoral bonds by the government of Eurocasia in 2024. The government of Eurocasia introduced a scheme that is electoral bonds, which is a promissory note that can be used by donors and can be issued by only the National Bank of Eurocasia, that too at very specific days of an year, which has to be notified by the certain bank. And it has certain denominations as well as provided in the annexure. Further, it incorporates what political parties can encash this. Only political parties who have attained 1% vote are registered under RPA can apply for this. My learned opposition have filed a writ petition before this honorable court contesting the constitutionality of it. If the honorable bench, your ladyships may permit, may we move to submissions with respect to that? Much obliged, your ladyships. Your ladyships, with respect to the first issue, we would like to humbly submit before this honorable court that the electoral bond scheme is constitutional, because A, it does not violate Article 19, B, it does not violate any other constitutional provisions, C, because of because of a lack of non-compliance of constitutional provisions, it is a policy decision of the particular government. With respect to the first submissions, we would only like to restrict our arguments to Article 19, which has been raised by my learned petitioning side, and not cover Article 14, if that may be okay with the court. Much obliged, your ladyships. Your ladyships, with respect to the first argument pursuant to Article 19, we would like to humbly submit before this honorable court that the electoral bond scheme is not in violation of Article 19, because Article 19 is not absolute in nature. Your ladyships, Article 19, though provides tons of freedom of speech expressions or other rights as well. However, they are to the purview of subjections under Article 19(2), which talks about reasonable restrictions. We would like to highlight to this honorable court what may construe as reasonable restriction does not have a set standard and differs from case to case basis. Noted by this.
Just to clarify, so you're saying that there is a threshold violation of the right and you're proceeding straight to it being a reasonable restriction.
Indeed, Your Lordship. With respect to, as we were talking about reasonable restrictions, Your Ladyships, we would like to provide that the reasonable restriction in this case complies with the procedure for it to be reasonable restrictions. Now we shall explain how this complies with the procedures. First, it must originate out of one of the 6 mentioned grounds in Article 19.2. This originates out of public order, which
Counsel, two separate things. One is reasonableness, a manner in which it has been executed, and the other is the grounds. Merely because one of the grounds has been invoked does not make it reasonable. So two separate limbs of Article 19.2 you have to talk about. Grounds on the basis of which you have restricted and the reasonableness of the restriction itself. So please clarify that.
Indeed, Your Lordship. Your Lordship, first, so then we shall be addressing the ground on which we have invoked this, and then we'll talk about the reasonableness. The ground that we have invoked this is public order. Public order is mentioned in Article 19.2. Your Ladyships, we would like to humbly submit that this particular invocation of restriction has been done in line of public order. Now for that, we would like to provide to this Honorable Court that public order has been read to be virtually synonymous with public health, safety.
Sorry, public?
Order has been
Public
held,
health,
safety and tranquility.
Okay.
What was the context in which that was held? Could you just explain to us?
Your Lordship, the context was it was held in the case of Ram Manohar Lohia
Yeah.
that public order, the term public order is synonymous with public health, safety and tranquility. Ram Manohar Lohia, the person was tried for asking people not to pay taxes. Indeed, Your Ladyship, we are not contesting whether it is linked with public health or tranquility. We are focused on the middle part, which is public safety. It was read synonymous with that. We were just providing the ratio before this code. We are only concerned with whether public order is synonymous with public safety or
Before
not.
we
in this
get
instance.
to what public order means, where have you mentioned public order as a ground for introducing this particular scheme?
Also, is it there in your law? Have you stated public order in your law when you have passed your law of electoral bonds? Have you mentioned public order as the ground? Or is that something that is the submission you're making now in defense of the law?
Your Lordship, the Moot proposition remains silent on that. So we would not like to comment or add any fact for that. So we cannot comment whether the government introduced via any press notification. However, in the gazetted order, they did not mention public order as a ground.
So counsel, you're just coming up with a new ground on the fly. There's no factual basis for what you're saying. You can't imagine grounds. You can't imagine that there is a country which might get offended by this and therefore say it's in justification of maintaining. It has to be some factual basis for your argument. Show us some factual basis.
Indeed. We would like to draw your attention when we talk about the Moot proposition, if your ladyships may move with me. So when we talk about the Moot proposition, if we may go to paragraph number 2. Paragraph number 2 talks about the election campaign made by the EDP, which is the incumbent government. It talks about that they made several promises with respect to clearing the framework of funding of politics, weeding out black money and corruption, and to decriminalize political spaces. Further, when we talk about this, the factual origination of public order is imperative to understand is on the consequence of the donor.
Sorry, on the consequence of the?
The consequence of releasing this information in the public on the donor.
Counsel, factual basis, not speculation. You have referred to the manifesto of a political party. A political party and the government are not the same thing. There is a clear difference. Where has the government, once whatever it is composed of, said public order or some aspect of public order is a basis for either passing the law or passing the scheme? Some factual basis show us that, counsel. You can't just argue in the air.
Your Ladyships, if you may please peruse through paragraph 5 of the Moot proposition and paragraph 7. Both of them talk about the objective of the particular law. The objective of the particular law is to make the system devoid of black money. Now this particular move has also been...
Tell us which line of paragraph 5 or paragraph 7.
Paragraph 7, my apologies.
Where does it say?
Jurisdiction has not been able to evolve into a clean electoral funding system devoid of black money until the arrival of electoral scheme. This has also been appreciated by various scholars. So the intention of the government, the objective is to deter black money and to attain
You
electoral
are talking
purity.
about the opinion of public commenters. I thought this is something that government has said. This is the problem. This is the opinion of, maybe they are right, maybe they are wrong, but they are not here before us. We can't cross-examine them. We don't have their articles before them. We don't have on what basis they are saying this.
We have if you may please peruse to paragraph 3 of the Moot proposition, the last line talks about the EDP government introduce a space of legislative reforms to serve the electoral
That
promises
just
they have
says that they introduce public order, some element of public order as the basis for lawmaking, not what other commenters saw and thought this is what it means. We want you as the government, you are appearing on behalf of the government, not the political party or the commenters. Tell us factually from your law, where are you talking about public order?
The government, in the facts provided to us, it remains silent as to whether the government provided such a notification or
Then
not.
how can you argue that? Counsel, you need to have some factual basis for your arguments. You can't just make up grounds on one day. Please move to your next argument.
If the learned your ladyship just may allow me to summarize how this impact.
Move on.
Should I talk about the reasonableness of the restriction?
Sure, you can. Go ahead.
Much obliged, your ladyships. Your ladyships, we would like to now talk about the reasonableness of the restriction. So when we talk about the reasonableness of the restrictions, it is imperative to note that the prevailing socio-economic factors must be considered, and the reasonableness connotates to various different thresholds. These thresholds that we talk about include being both procedurally and substantively reasonable in nature. For procedurally being in nature, reasonableness, we would like to direct your attention to the Moot proposition, note to the participants provided on page 8. Your ladyship, with respect to the reasonableness of procedure, point 1 categorically provides that the Finance Act, which introduced the electoral bonds and made the requisite amendments, is done through proper constitutional methods, and there is no challenge on that.
Counsel, no one's contesting that, so just move to the actual points in
Indeed.
contest. Yeah.
So when we talk about this,
Just a minute, are you saying that completely meets the requirement of procedural reasonableness and there's nothing else in procedural reasonableness that needs to be met here?
your ladyship, we are not postulating that that is the submission, but the proposition itself asks us to only argue on merits of the substantive part, not the procedure part. Thereby, we are restricting our arguments for substantive part. That is what we are providing.
Procedural part in terms of the fact that it was legally passed. So is the legality the only thing of reasonableness? Or is there more to reasonableness than legality?
There are more things to reasonableness that we are propounding upon. That is the proportionality aspect. And when we talk about proportionality aspect, we would like to talk about how it fulfills the four-prong test developed by this code. Now, the four-prong test has been noted in various judgments in the Modern Dental College judgment and the Puthaswamy judgment. So when we consider this, there are 4 limbs to it. That there must be a lawful object. Second, there must be a rational nexus with the object of the legislation. Third, it must be the least restrictive alternative. Fourth, there must be a proper balance. So when we talk about the first point, indeed. So for that, the only other option that exists is to make the whole system pure is for state funding of elections.
No, that's not the only possible option. There are, within this scheme itself, there are about 15 amendments which are possible to make it better. None of which you have done.
Your ladyship, we would like to humbly submit that we agree that the bench might be postulating that there might be other
Counsel,
aspects as
it
well.
can't be that your proportionality argument hinges on your opinion versus my opinion. There has to be a legal test. There has to be a constitutional test to it. What is it, a least restrictive doesn't mean there are maybe other policy ideas which could perhaps at some point be done. In the context of this scheme, you have not taken us through the scheme itself. You expect us to generally listen to your arguments in the air and say, please uphold this. Take us through, show us what is reasonable about the scheme.
And while you're doing that, just to add to my learned brother's question, can you also explain to us what is the legal standard in the third prong? So, two things. One is that on which party does the burden lie to demonstrate the existence of alternatives? So if it's been shown that there is a prima facie violation of a constitutional right, then who bears the burden under prong 3 to demonstrate that alternatives exist or not, and to what extent has this burden to be fulfilled? So to what degree of specificity must it be shown that there do exist alternatives that are less restrictive? So when you're answering Malala to this question, just weave the legal standards into your response so we can have a complete sense of your argument.
Indeed. So, to answer both of the questions of your lordships, we would like to talk about the object of the legislation and the certain measures provided in Annexure 1. Now, the object is to deter black money from the polity scheme of Eurocasia and to attain electoral purity. Talking about how it is rational in this instance, if we peruse through Annexure 1, it talks about incorporation of various KYC norms. Specifically, Section 4 talks about that there is an application of KYC norms done by only the National Bank of Eurocasia. Further, it provides that there are anonymous safeguards pursuant to this, that is an application will be rejected if the particular KYC norms are also not complied with. Further, it shall be on the branch to examine whether these requirements are correct or not. Only after that, the particular bond shall be issued. Further, it is imperative to note that because of this whole process, it leaves a paper trail behind for all these funding. It makes it documented, which in turn becomes very responsible for getting to any charge of malafide or prevalence of black money in the polity scheme. Talking about how it connects to being the alternative in this particular section, we would like to provide that we attest to the fact that the burden rests on the state to prove that the restriction is reasonable or not, but essentially in this point what we are connotating is that there is no other measure that is that exists to achieve what this law is going to achieve, with this all the nuances that the law provides.
You're literally equating least restrictive alternative to the Tina Bank.
Pardon your ladyship?
You're equating least restrictive to there is no alternative.
No, your ladyship. So when we talk about this incumbent legislation that we have passed, there is two understandings to note that. We do attest that there is no other prudent grounds available over here, but it is also imperative to know that is very fundamental. So if we understand the scheme of how polity works in Eurocasia, it has been flooded with black money. Therefore, at this moment, it is very imperative, considering the socio-economic prevailing conditions, to enforce such a law.
So counsel, if I, sorry.
No, go ahead.
So if I understood your question argument correctly, you're saying that the objective is to weed out black money in the election process.
And attain electoral purity.
Well, by weeding out black money, and the only way of achieving that is there's no less restrictive way of achieving that than this law. Right now, their main case before us was that the main issue that they have with it is that people don't know who is donating to whom, and that's where the problem is. So what if everything else here was kept the same, except the anonymity requirement? And right, would you be okay with that? Because you'd still have your black money problem being solved, paper trail all there, but now the people know what's happening. So would you be fine if we were to pass an order striking down that bit of the electoral bond scheme?
Indeed, your lordship. Your lordship, we do attest to the fact the relevance of doctrine of severability, but in this instance, we would like to humbly submit on behalf of the state that presence of section 7.4 provided in annexure, which talks about the confidentiality and anonymity of the donor, is very fundamental in this instance. This is to preserve and protect the existence of a donor from threats and coercion.
No. This is the important thing. That's a different argument. That argument is that you need to balance rights. Donor's right to privacy versus right to information. Right now, I'm asking you that isn't this, if your goal is weeding out black money, then a law that has everything that this law has, but has disclosure requirements, would achieve the same goal and be less restrictive of the Article 19(1) rights. So therefore, the proportionality test comes out against you. That's my question to you.
Just a minute, your lordship. Right, so when we talk about this, we do attest to the fact the proportionality scheme that your lordship is postulating, but again, the objective of the legislation is to curb black money with attaining electoral purity. This purity that we talk about is fundamental in this instance by protecting the particular right of a donor in this instance. The right is not to be threatened or coerced. this threaten and coerce that we talk about originates that when the information of a particular donor is released, they will be threatened, there's a possibility that they will be threatened or coerced by other political parties. Also, it is pertinent to note that big corporations shall not be forced by any political party to vote for them. Thereby, and I would like to highlight this point, my learned opposing counsel in the submissions provided that this information will rest between the donor and the political parties because they will be privy to this information. However, we would like to draw your attention to the annexure of the Moot proposition, section 7, subsection 4. It categorically provides that only the bank and competent law enforcement agencies will be privy to this information, not the political parties. Even the political parties who are receiving this funding will not know the name of the particular donor and will not know who is donating in what amount.
Counsel, two questions. What's your understanding of black money?
Your Lordship, very simply, in common parlance, black money is which is unaccounted for and which is unaccounted for and is procured or transferred through illegal means or sources.
Is that all? Is there one more element to it?
That's not all. That's not the exhaustive definition, but that's the definition that the council can think of the top.
Now, how does, here is the dichotomy, all right, and this is where you have not been able to address this point. Electoral bonds, money that comes to electoral bonds escapes taxation, correct? Nowhere in your scheme is the person who is giving this money required to show the source of the money. KYC only asks who are you. It's only about finding out whether you say who you really are. It is not asking for income tax returns. It's not asking for sources of money. It's not asking for anything. I could literally walk into a bank with 20,000 in cash, come out with 2 electoral bonds. Nobody will ask me a question as long as they're satisfied. I am so and so who claims to be so and so. How does your own scheme actually fight black money?
Indeed. So when we talk about this, when you talk about the notion of KYC, KYC is done considering the person's personal information, and
I understand that. You don't have to explain that to me. My only question is, where it is anywhere in the scheme are you required to show the source of your income or source of the money from which you're buying these electoral bonds?
The scheme does not talk about the source of the money has to be disclosed.
Therefore, and because we've just said black money is about the source, unaccounted for, you don't know where it's come from, you don't know whether tax has been paid on it, you know it probably has been acquired illegally. You can literally use black money to buy electoral bonds. How does it how does it serve the purpose?
Your Lordship, I see my time has run out. Can I be
No,
granted?
answer that, yeah.
With respect to that, we attest to the fact that the source of black money is particularly not present in the annexure 1 which has been talking about. However,
it's your law, your scheme.
Yeah, so we would be open for guidelines from the government if they wish to incorporate anything from the electoral bonds.
So we'll strike this down, you come up with a better law.
Your Lordship, we would like to humbly submit that the threshold for striking a law has not been met by the petitioners in this instance.
That doesn't matter, we are convinced.
Your Lordship, we would like to humbly...
No, the problem is that what my learned brother has pointed out is that your rational nexus prong is not being met. Your second prong is not being met. So if your goal is black money, and if this still allows for black money to be used to finance electoral bonds, then your prong 2 is a problem, where you have to show a rational nexus between the scheme and the goal of preventing black money.
So for that, we'd like to shed some light on KYC norms that a bank undertake. KYC norms undertake your name, your personal information, and your particular transactions that happen in a banking system. If these transactions have been out of proportion, they will obviously be a check that the bank can enforce. The bank can either reject this application or the bank can accept this application. The bank inherently holds the last right in this to either issue this bond or not, specifically mentioned in section 7.3. If your lordships may, if your ladyship may allow, may I quickly move on to issue 2?
Rejection cannot be done according to the scheme provided by you. It can
Pardon,
be,
your lordship, you're not audible.
I'll tell you.
So
The rejection is only placed in clause 7(5), subclause 5. It says that in a non-KYC complaint application or an application not meeting the requirements of the scheme shall be received, not otherwise.
So KYC itself talks about the importance of the money that is being procured into this. If your ladyships may allow, I'll quickly cover issue 2 in brief so that I don't take too much of the court's time. Your ladyships, with respect to issue 2, we would like to humbly submit before this honorable court that the freeze on delimitation introduced is first constitutional Second, that the current process of apportionment of seats to particular states is constitutional, and the process of apportionment of seats to reserved categories is also constitutional. With respect to the first part, we would like to, at the very outset, my learned opposing counsel here are talking about that the constitutional amendment is violative of the basic structure. However, we would like to, at the very instance, talk about that they have failed the responsibility to show how it violates the basic structure test. They talk about it being violative of basic structure. They have neither invoked the width and identity test nor the rights and rights of essence of rights test. Just covering the submissions briefly. Firstly, we would like to provide that this particular freeze on delimitation is not violative of basic structure doctrine, as my petitioners are arguing that it is violative of one vote, one value. Now, your ladyship, we would like to draw your attention. This concept is not a mathematical proportionality and cannot be construed for strict enforcement, noted by this court only in RC Podial. Therefore, this strict enforcement of one vote, one value cannot be adopted for postulating a claim that it violates the basic structure itself. One vote, one value is an aspiration, not a rule that the court has to follow. This court only noted this, and they have to follow to the limit as it is possible.
Counsel, there's no disagreement on that as a matter of principle. If you're departing from it, there has to be some reasons for it, as Podial itself held. Now, in para 42 of your memorial, the reason that you seem to be giving is that states that have been successful in lower population growth rates are being punished by this delimitation. So my question to you is that, are you punishing states or are you punishing people? Because you're making people, their votes carry less value, and surely the people are not at fault because their government did not have a good family planning policy. So why are you framing this as a punishing successful states issue when actually you are devaluing the vote that each individual person has in a more populous state?
Indeed, Your Lordship. To answer that, we would like to provide that this particular deterrence has been placed to essentially talking about the family policy aspects. We attest to the fact that this might act as a deterrence for states who are underrepresented, but it is also to consider that the states have failed vehemently in the enforcement.
No. Can I, as a voter, have my vote devalued because my state government was bad at family planning? That's my question.
Your Lordship, for that, we would like to humbly provide. Can I just wrap up the submission?
Answer the question. Yeah.
Indeed. So we would like to humbly provide that this not only for deterrence of northern states, it also ensures the federal balance in the country. That's not the only argument for that. It also ensures federal balance by providing equitable representation for southern states who were very well in enforcing these mechanisms, and if that is not undertaken, they shall be underrepresented, not in accordance with what the postulation of freeze on delimitation was. Lastly, we would submit that this particular apportionment of seats is not unconstitutional with respect to reserve categories, because unequals cannot be treated with equals, and therefore in line of Article 14, the reserve categories hold this particular ambit to be provided reservation based on the latest census. With that, the council would like to rest the submissions. It was indeed an honor arguing for such an honorable bench. Thank you so much, your ladyships.
Honorable bench, council solicits permission to begin. Council solicits permission to refer to the bench as your lordships and ladyships. Much obliged. Greetings to the bench, my learned opposition, the court masters and everyone present. The current council will be taking 20 minutes of the court's time to deal with the subsequent two issues. I will firstly be dealing with why section 8B of the RPA is not in violation of the fundamental rights and is constitutional under issue 3. And then as to why section 62(5) of RPA is also not in violation of the fundamental rights and constitutional. With respect to the third issue, section 8B is not liable to be struck down as being unconstitutional, and the council would be making the following arguments in furtherance of the same. 1, that the act does not violate article 21 of the constitution. 2, the act does not violate article 14 of the constitution. And thirdly, that the act has more than sufficient safeguards to deal with any plausible misuse. Now, with respect to the first submission, it is important to note that both the rights that were cited by my learned opposition under the as being under the purview of Article 21 and hence in violation of the same, namely the right to vote and the presumption of innocence, do not fall within the ambit of Article 21. The right to be elected is not a fundamental right. It is a statutory right and can hence be exercised on the conditions laid by the relevant statute. The same has been held in the case of Rajbala versus State of Haryana, Javed versus State of Haryana, and several others. Now, even if we are to engage in the Article 21 argument, it is pertinent to note that the procedure established by law has been followed in the said case. Now, legally, the prevention of entry into criminals is regulated by providing certain qualifications and disqualifications, as can be seen in Article 84 and Article 102 of the Constitution. Now, what is important to note is that both these provisions also entail within them any law made by the Parliament. Hence, through the Representation of People Act, Parliament is essentially prescribing further qualifications and disqualifications in furtherance of the same, to which such right to contest elections can be subjected. Hence, the amendment of Section 8B to impose reasonable restrictions is in accordance with the procedure established by the law. Now, we also understand that there are other requirements as to reasonability and unarbitrariness of the legislation. With regards to reasonability, now the courts have on multiple occasions insisted that the Parliament pass a legislation which would impose such restrictions.
Those were courts in different countries. Counsel, very simply answer for us this question. Why has framing of charges been chosen as the point at which disqualification takes place?
Right. Your Lordship, in fact, we would have addressed that in our second submission.
Go to it.
Right. With respect to the framing of charges has been set as a threshold as it directly subserves the objective that the law seeks to achieve. Now, if we examine the legislation of Section 8B against the touchstone of the reasonable classification test.
Forget about the reasonable classification test. I'm asking for a factual answer.
Right.
Why has framing of charges been chosen as the point at which, okay, you say the larger goal is keeping criminals out of politics.
Right.
A complaint can be filed against you. It can be turned into an FIR. Charge sheet can be framed against you. Charges can be framed against you. You can be convicted, sentenced afterwards, right? You have chosen a particular, very peculiar point, which is framing of charges. Why?
Your Lordship, with respect to that, I would make two arguments. Firstly, in order to understand...
Factual reason.
The factual
Why?
understanding would be, it is important to note that threshold of framing of charges has been established because as pursuant to Section 228, pursuant to which framing of charges takes place, involves a substantial amount of judicial scrutinization that takes place. And hence what we are saying is, when viewed again, and then when this is examined in the backdrop of the objective, this understanding becomes even more coherent. Now, like I was saying...
So is your argument that the reason why it's framing of charges is because that's the stage at which a court considers the accusations against the person and finds them to carry some degree of weight? Is that the argument?
Yes, Your Lordship, it is. But this also becomes more coherent when we see how it directly speaks to what it is that the law actually sets out to achieve. If the court may please, shall I elucidate upon the same? Much obliged. Now, the two tests, the two limbs under reasonable classification are one, intelligible differentia, and second, that there must be a reasonable nexus. Now, intelligible differentia is one that is understood, that can easily be construed. Here, the distinction that is being drawn under Section 8B is between those against whom charges have been framed and against those whom charges have not been framed. This is an intelligible one and one which is easily capable of being understood, since against one set of person no such framing of charges has been framed, as opposed to those people against whom the courts has taken a judicial notice of a prima facie existence of an alleged offence. Now, what are the objectives of the acts here? As can be deduced from paragraph 10 of the Moot proposition, one of the objectives is to send positive signals about the purity of democracy to the rest of the world, democracy of Eurocasia that is. And second is to decriminalize the political sphere. Now, in pursuant to framing of charges, both these objectives are being achieved. Now, as we have already mentioned, since Section 228, under Section 228, a substantial amount of judicial scrutinization takes place. Also, at this juncture, it is important to note that those people who are actually being debarred from contesting elections are not those against whom charges have been framed, but those persons against whom charges have been framed for an alleged offence which would mandate an imprisonment time of 5 years or more, which also rebut the contention made by our petitioners when they went on to say that it is a blanket ban and a distinction needs to be made. A distinction has been provided for. Now, when such person, when a prima facie existence has been taken cognizance of by the court against a person for such a serious offence, when such people are handed out tickets to contest elections, it directly hampers the purity and the image of democracy of Eurocasia.
Counsel, what do you just so I understand, what in your view does the term purity of democracy mean?
Purity of democracy would entail a clean and a good image of the institution of democracy of the country, one which in the present context would be free of any criminal elements.
That's a definition of purity of democracy.
Yes, Your Lordship, that is what we understand from the purity of democracy, and that is what that is what when we look at section 8b, that is the aspect of purity of democracy that is being trying to achieve. Because there are, as can be deduced from annexure 2 of the Moot proposition, there is a rapid increase in the number of criminal elements in the political sphere. Hence, when such people against whom such judicial notice has been taken contest election, it further hampers the image of democracy of Eurocasia. And by posing a restriction on such people from contesting elections, the threshold of framing of charges directly subserves the objective of the act, which is...
Counsel, you would have noticed in most countries, even allegedly pure democracies, you will find that criminal law disproportionately targets minorities, previously oppressed classes, basically economically disadvantaged groups. Don't you think this measure also discriminates against them?
Your Lordship, with respect to that...
to give you an example of India, you will find Muslims, Dalits, Adivasis grossly overrepresented in the prison population because they don't have the resources to get a lawyer to defend themselves or to get charges framed against them. Don't you think this will disproportionately harm these communities?
With respect to that, Your Lordship, those who had been convicted were by the earlier law itself not been allowed to contest elections. What we are...
We will get to that law separately.
Yes.
Right? That's not what is currently subject of discussion. This is a section that you have introduced and they have challenged it. We could use this as a basis to strike that down also. Satisfy us that this doesn't disproportionately affect minorities, oppressed communities, and Dalits of course are in our state as well. How do you say that they're not affected by this?
Your Lordship, by way of this legislation now what is happening is some people against whom charges have been framed are being debarred from contesting elections. Again, the 5-year distinction is being drawn. What we would like to submit here is that first of all, section 228 in itself entails an amount of judicial scrutinization which the court applies. Furthermore, in addition to that...
Counsel, even that, please understand the procedure. Charge sheet is filed, arguments are addressed. The point I'm trying to make is that a lot of accused don't even have the wherewithal to get a decent lawyer who will say why charges should not be framed. The reason why conviction may be okay is because the burden is still on the prosecution to prove it. You can literally not lead single piece of evidence and still be acquitted. But for charges, there is no burden on anyone. The court just looks at evidence available, looks at arguments and frames charges. The threshold is much lower. Don't you think, and given this, it will disproportionately affect such communities even if there is judicial oversight?
With respect to that, Your Lordship, what we would like to state is, in addition to section 228, while there might be certain exceptional circumstances where certain people might not be able to procure lawyers or bonds or things like that, what we would like to state is that in addition to section 228, there are also other legal safeguards that are both inherently present in the law and have also been introduced by way of section 8b, pursuant to which any such attempt would be obviated.
What are they?
Yes, surely. Now, Your Lordship, with regards to that, it is also important to know that our petitioners contended that there are no adequate safeguards, and this would also rebut the same contention by my petitioners. Now, First of all, the Supreme Court has prompted the executive to undertake such a legislation, as has been mentioned, and while doing so, they also took into cognizance the possibility of false cases being foisted on prospective candidates. Despite of which, they said that such a law should be enacted, which signifies the weighing of interest and the urgent need for it. Now, with regards to the safeguards that
I want to come back on this weighing of interest bit, right? Because again, as my Reverend brother said, this is Supreme Court of India. We're not in India. What this law does is that it takes a set of people and it excludes them from the electoral process. It basically deprives the citizen of the ability to vote for a candidate of their choice potentially by just removing them altogether from the list of possible options. Now that is a very serious incursion into democracy, since you're on impurity of democracy. Right? So that's a very, very serious infraction of democracy and requires a correspondingly high degree of necessity and a very narrowly tailored law that can justify that, because what you're doing is a very big deal. Right? And so therefore you can't just say there may be a few exceptions, there may be some problems here and there, it's fine, it's okay. That can't be the case in this law, because you're basically saying that you as a citizen don't have the right to vote for whom you want because we are taking them out of the stream altogether. So then you have to show safeguards that merit a balancing of interests, where the interests in ensuring that people can vote for whom they want are respected and are paramount.
Yes, surely. I will address all the legal safeguards that have been provided, and as to why those people who are being debarred from contesting elections are being done so on a rational basis. Firstly, like I said, there is it shares the nexus with the objectives that the law seeks to achieve. Now, it is important to note that first of all, before delving into the multiple legal safeguards that are present in the legislation, as can be clearly seen, the law that is currently, the legal framework that is in place to regulate entry of criminals into the political space is clearly not subserving the objective of the Act, as can be deduced from a reading of Annexure 2 of the proposition. Now, with respect to the multitude of safeguards that are present, firstly, the type of offences which mandate the disqualifications of individuals from contesting elections has only been set at those which mandate an imprisonment time of 5 years or more. Hence, which would automatically make it harder to furnish such false cases and obviate any such attempt. Secondly, a stipulated time period has also been provided for, which states that if the framing of charges has been done within the 1 year period, it would not attract a disqualification, which again would serve as a deterrent from any furnishing of false cases or any other attempts to solely pursue such framing of charges in order to debar someone from contesting elections, let's say. Thirdly, as we've already elaborated, section 228 itself delves into an amount of judicial scrutinization. However, additionally, as per section 311 of CRPC, which has been reproduced in page 35, paragraph 82 of a memorial, this also bestows upon the Supreme Court an additional right to further delve into the material on record in more depth when it feels that the framing of charges is of severe consequences, such as in the case of debarring someone from contesting of elections. Additionally, when we say that by virtue of section 8B of RPA, nobody would wrongly be disentitled from the right to contest elections, we say this, we have to undertake a conjunctive reading of the 1 year stipulated period that has been mentioned in section 8B, and the judgment of, in Public Interest Foundation, wherein it stated that cases against MPs and MLAs should be tried in a speedily manner and be concluded within 1 year. Now, I will help with an illustration here. Let us say a case is filed within the 1 year period, 1 year before. Now, this would not automatically attract any disqualification. And if it, then that means essentially any such case would have to be filed before the 12-month period. Now, if a case is filed, let's say 16 months before, given that the case would have to be concluded within a 12-year period, the person would either have been acquitted or convicted. Then, subsequent to that,
where in your legislation does it say that the trial has to be completed in 12 months?
This we are relying from the case of Public Interest Foundation.
That's in a different country.
Yes, however, the laws and the judgments are pari materia.
Where does it say they're absolutely binding? Why are you bound by the judgment of another country in its actions? What consequences can possibly the Supreme Court of India apply on the courts of Eurasia?
They are not absolutely binding your lordship.
Is there any provision in your law which says that trials have to be completed in 12 months?
No. While the stipulated 1-year period has been mentioned in section 8b, we are also open to undertake and incorporate any suggestions.
Then we will strike it down. You pass a fresh law. We'll give you all the suggestions, but we'll strike it down.
Your lordship, we would like to contend here that since a lot of legal safeguards have already been present, merely this 1-year stipulated period as has been mandated in public.
I understand the point about procedural safeguards, counsel. I'm asking about something slightly higher than that. What I'm saying is that this has disproportionate impact. And I said disproportionate impact specifically in the context of certain vulnerable communities. What do these specific vulnerable communities or contestants from these vulnerable communities, how will they be able, what are the procedural protections you have to ensure that this does not affect them disproportionately?
Again, with respect to that, your lordship, the submission would be that essentially because there is such a long process of judicial application of mind that is undertaken, it would not discriminate or draw a distinction between against the socially backward or economically backward classes, and hence would not disproportionately affect any sections of the society.
Okay.
Hence, your lordships and your ladyships, what we are essentially saying here is that given the concern of criminalization of politics in India, disqualification at the stage of charging is justified considering the substantial attendant legal safeguards that are present. It is also pertinent to note here that in Public Interest Foundation, when it directed the Law Commission report to undertake an examination about two things, one of them being whether or not section 228 pursuant to which framing of charges takes place is an apposite stage to debar people from contesting elections. The Law Commission, the 224th Law Commission report said, and I state, that the stage of framing of charges is based on adequate levels of judicial scrutiny, and disqualification at the stage if accompanied by substantial attendant legal safeguards to prevent misuse. It is also important to note here that all of the legal safeguards that were mentioned in Law Commission report have been incorporated in the said legislation, would have significant potential in curbing the spread of criminalization in politics, which directly speaks to the objective that the law seeks to achieve. I see that I'm almost out of time. Can I quickly make my submissions with regards to the fourth issue? Much obliged. With respect to the fourth issue, the respondents would submit that the Act does not violate Article 14 of the Constitution and that the Act does not violate Article 19 of the Constitution. With respect to the first submission, as has already been mentioned, the twin tests laid down in Anwar Ali Sarkar, one, that there must be a differentia, second, a rational nexus. Now, the distinction that is being drawn here is between those who are in the confines of prison and those who are not within the confines of the prison. Now, the objective of the Act, the court is already privy to the objectives of the Act.
No. Please clarify that.
Yes. Now, the objectives of the Act, RPA, broadly is to decriminalize the political sphere.
I understand decriminalization with respect to people who have criminal past antecedents contesting elections. I don't see how that is the same as letting people, as preventing people who may be in prison for whatever reason from voting. How is that criminalizing politics?
Right. With respect to that, Your Lordship, we would like to cite the case of Anil Deshmukh and Nawab Malik versus Directed Enforcement and other cases such as Public Interest Foundation. I see that my time is run out. Can I quickly answer that? Much obliged. They had mentioned that in order to obtain political purity, it is important that people with blemished characters and tainted integrity do not partake in any part.
So what were the facts of Anil Deshmukh? What vote was that?
In the case of Anil Deshmukh and Nawab Malik, the two were essentially seeking an exception to section 62(5) of RPA in order to be able to vote in the Maharashtra Legislative Assembly.
Which is not the same as an election, like a general election or a state election that a citizen votes in.
Right. While we understand, Your Lordship, that the factual matrices are not similar, we are relying on the relevant portion of the judgment and not...
If in Anil Deshmukh's case, the whole point was that the election in question was an indirect election in the Rajya Sabha, where again you have members of parliament and the legislature voting, then whatever, we can still see the rationale and the connection with decriminalization that you have brought up. Any person who exists in the country happens to be in jail, how is that the same as preventing an MLA or an MP from casting a vote in the House? They are two very different things. So how can you use the relevant portion to say that two are the same?
Yes. Your Lordship, what we are postulating here is that even if we are to not take into consideration the case of Anil Deshmukh and Nawab Malik, it is important to to regulate the people who partake in any process of the electoral institution in order to maintain the integrity of the democratic process. Again, even in the case of Public Interest Foundation, a similar concern has been voiced, as well as in Law Commission reports. Hence, what we are saying is that those people who are within the confines of the prison, subsequent to and as a direct consequence of their own acts, do not be allowed to partake in the electoral processes. Moreover, we are also stating that what we seek to do is decriminalize the political sphere. It is felt that now the agenda of a politician is mandated and regulated according to his constituencies and the electoral base. It would not be plausible to strong arm any right serving member of a political party or anybody else to actually tackle these criminal elements if they are actually allowed to be dispersed into the electoral base, since it is their interests that the politicians are directly meant to.
So you're saying that a person in prison has only one interest, which is his identity as a prisoner. He or she has no other interests, interests in development, in food, in schemes, and all of those other interests that a citizen might have effectively become irrelevant when they're put in jail. So none of those other interests count anymore because they're in jail. Is that the argument?
Look, Your Lordship, what we are saying is that in light of the fact that there is a steep increase in criminalization, the state here has two options. One is to be under cautious, one is to be over cautious. Now, as we can clearly see that the laws that are currently in place itself are not adequate to regulate the criminalization in politics. Being under cautious here would expose us and make us susceptible to further entry of criminalization in politics. What?
Is this just being under cautious, or is this violating a very basic rule? Governments cannot disenfranchise without a really high standard.
Your lady.
What's the high standard that you have met? The disenfranchisement is a very different aspect. It's not just about being under cautious.
Your lady.
It should be subject to a higher scrutiny. So what is that higher scrutiny that you think we have passed?
Also, under the rise of correcting the system, we cannot take away the fundamental right of voting. There are a lot of people who are in the jail, even they are innocent. So how are you going to just like how man said that? How are you going to have a higher focus and tough scrutiny where the fundamental right of voting is not taken away?
I just think of all the people trial courts convict who are then found innocent by the High Court and the Supreme Court years later. You're saying that they shouldn't vote, that the drastic consequence of just taking away the right to vote on the basis of even in cases where there are convictions that are often set aside.
Your Ladyships, Your Lordship, with respect to that, what we are stating is that the distinction that is being drawn in furtherance of on the basis of which certain people are being disenfranchised from their right to vote is one that is essentially mandated and necessitated in the backdrop of the social exigencies of Eurasia, and two, that again it directly speaks to and subserves the objective of the legislation as well as the act in the broader context. I see that my time is run out. Shall I move on to the prayer?
That's okay. I think we have.
Much. Thank you, Your Lordships and Ladyships. It was an honor arguing before the bench.
Is there a rebuttal or is there no rebuttal? There's rebuttal, right? Okay.
Yeah.
Greetings to the bench once again. Your Honor, what has been observed by the petitioners in the given case on virtue of the memorial that has been submitted by the respondents is that in issue number 1, the only thing whose constitutional validity has has been tried to establish by the respondent is the EFB scheme, whereas the issue also called into question two amendments that were made by the Finance Act in the RPA and the Income Tax Act. These two issues, Your Lordships, were not addressed by my worthy opponents, and therefore I would like them to address the same, because their constitutional validity is also being called into question. Your Honor, now secondly, moving on to the very facet that petitioners have stated and also believe that there is a mechanism in which only the political party, which is the donor and the donee in the given case, will get to know about the donations being made and nobody else. Your Honors, in order to establish that, I would like to redirect this Honorable Court's attention to clause 12 and clause 14 of the EFB scheme. Your Honor, it needs to be understood that the National Bank of Eurasia is A, issuing this bond, B, this bond needs to be encashed by the political parties by submitting it within 15 days, which means there is a physical transaction that is going on. And Your Honor, nothing in the scheme has provided or established that National Bank of Eurasia is acting as an intermediary in order to ensure that donors and donee do not get to know about each other. Therefore, the common presumption or the only presumption that can be followed herein is that the donor and the donee are the only people who are getting to know about this information, since the trade is happening since the trade of bond is tangible in nature, and therefore, Your Honors, further moving ahead, my worthy opponents have submitted that the EFB scheme passes the twin test under Article 14. However, the classification that they have made herein is with respect to the political parties who are eligible to get bonds. However, Your Lordship, in paragraph number 15 of the submissions that my worthy opponents have presented, they have established, and I quote, that the reasonable nexus herein is that if the said classification, that is which political party can ultimately get the electoral bonds, that if such classification is not created, any individual or group of people may form a party or contest election and then might be presented with an opportunity to misuse these EFB schemes. Your Lordship, that inherently establishes that my worthy respondents are somewhere admitting that there is a possibility of misuse of this EFB scheme in order for siphoning black money, as they have submitted in paragraph 15. However, the only distinction that this provision is serving your honors herein is that it is only allowing now a particular set of political parties to siphon black money using the EFB scheme, which ultimately defeats the entire object of the act. Your Honors, my worthy opponents furthermore did not explain how innocent people who are within, how innocent people's right to vote or right to contest election is being protected herein. Your Lordship. It was indeed an honor making submissions before this honorable bench, Your Lordships.
Your Ladyships, to counter what my learned opposition have been postulating, so they talk about pertinently as to why the political parties will have access to this information. We would like to reiterate the fact that a basic reading of section 7, subsection 4 categorically provides that this information about the identity of the donor shall only rest with the banking system and competent law enforcement agencies. Nowhere it mentions or it leaves a scope to be interpreted that the political parties will also be privy to this information. This is rather an over assumption of fact where the law itself is conducive and clear about who will have this access. They talk about that we have not addressed the issues of pertinent to the amendments. However, we would like to humbly bring to the notice of this honorable court that my learned opposition themselves restricted their arguments pursuant to Article 19 of the Electoral Bond Scheme. That is what the petitioners have postulated, and we, the state, has only to rebut that claim. Moving forward, they talk about our submissions pursuant to Article 14 in a written memorial. However, we would like to humbly provide before this honorable court that my learned oppositions themselves have not argued Article 14